Emergency placement change. Sexual abuse between siblings. Mom's gone, no contact in a month. Today, the goal changes to adoption. Case 24-001A. Let's dive in.
We're back on record for a review in this case. This case was continued after some facts came out of the record that clearly needed to be reviewed and investigated further before proceeding with our formal review on record. So I look forward to any additional developments after appearances.
Lee Heiss, lawyer, guardian ad litem.
Ms. Tasha Thomas, counsel for the department.
Kristen Smith, foster care worker, cafeterias.
Alexis Stang on behalf of Ariel Berger and the respondent mother.
And have you heard from your client?
I have not.
All right. We have obviously started a little bit later today and confirmed that she is not here either. So, all right. At our last juncture, I think we were literally in the middle of the testimony from your client, Ms. Thomas, but does anyone wish to bring anything up preliminarily?
Yes, Your Honor, we do have an updated court report, and it lays out all the pieces that I was missing in the past. And Ms. Thomas has met with the agency and reported back to me, and I believe all the missing pieces have been filled in for my investigation, and all my concerns have been answered. And so I will rest on the same visit that I had with this child at his home before our last, before the review, before we adjourned. Thank you.
Anything preliminary, or would you like to dive into testimony?
I'll just take testimony from Ms. Smith, and I think that she can also answer questions about whether mom knew about the hearing.
All right, Ms. Smith, come on up to our witness.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Didn't you need your phone today?
Sorry, what?
Did you need your phone yesterday? Was that you?
No.
Okay, never mind.
Been a busy week.
Already.
Yes.
Okay, well, this is really on this guy. Okay. Ms. Smith, you, at the last hearing, you were testifying about some placement changes for Sammy. We're not on YouTube. Oh, we are. Okay, for the child. So I just want to go back and just make sure we have everything about mom. I believe that you had testified to her compliance with the benefit from her case service plan, correct? Okay. And has there been any update since then about her engagement with services?
No, not to my knowledge. The last time that I had communication with her was at our last court hearing. I had texted her and let her know that it was adjourned. I gave her the date and the time, and that I asked for her to confirm that she received that information. And she texted back and said yes, that she had received it.
And you had that as a screenshot in your report,
yes,
correct?
I did. And also attached was just a few other drug screens since the last hearing that she has also no call, no show.
To the best of your knowledge, since your last testimony, has she had any contact with her child through her sister?
She has not. She has not seen her son in a little over a month.
All right. So at the last hearing, there was some concern about the maybe abrupt change of placement for the child. And thank you for including all of the needed documents in your report. At this time, as relates to the placement change, are there any, can you please summarize again what happened that created, when you use the word an emergency need to change the child's placement?
Yeah, so when we received the case transferred from DHS on September 30th, we had our case transfer meeting. At that time, it seemed like it was a pretty cut and dry, case. They gave us updates on where mom was at, what was going on with placement. And then because there were no, immediate needs, I, at the day that we got the case, did not dive deep into the details of the case. The very next day, there was a call in to CPS that at school there was an incident between the child and then 2 other children at the school. This child had convinced the other boy at school to touch a little girl's vagina, which he did. That was called in. So then when I found out and that I had to go meet with the child, we had concerns that, is there a history of sexual abuse in the case? Was this something that, has happened in the past? Because I wasn't familiar with the case. I weren't really sure. At that point, we did contact DHS. They said that they were also shocked. The person that I spoke with at DHS said, to her knowledge, she wasn't aware that there was a history of sexual abuse. At that time, I said, okay. Myself, my supervisor, met with the child that day at the YMCA in conversation with him, kind of about just his placement, how things were going in the home, the normal conversation that we have with kids. He did disclose a lot of concerning statements. He said that his brother, he doesn't feel safe in the home with his brother unless Mr. Boone was there, the caregiver at the time. He said that his brother, he probably told us 8 to 10 times that his brother was inappropriate and does inappropriate things. We asked him to kind of elaborate on that, or can he explain what he does that's inappropriate? He had said that his brother will pull his own pants down and that he had exposed himself. And we said, well, what happened next? What did you do? He said that he did tell the caregiver, and then when we asked what happened, when he shared that information, he said he couldn't remember and then kind of got off topic and didn't want to talk about it. He also said that we asked him, when his brother does inappropriate things, what does he do? And he said sometimes he just pretends like he's napping or sleeping. So that conversation and all of those concerns was a second call-in that we had reported concerns in the home. At that time, we had not met the caregiver. We had tried to contact him multiple times throughout the day at his home. We even called his work. We contacted DHS and asked if this was common and if he was difficult to get a hold of. They said, no, absolutely not. So they even tried to call him. He never responded to their calls either. When he finally did call me back, it was after hours, and I wasn't able to meet with him that night. I kind of explained what the concern was. And for that night, we asked for the child's brother, who was in the home that we had concerns for. We asked that he be safety planned out of the home and go stay with grandma just for the night. That way we could meet with the family the next day to get more information and details. So that took place that night. And then the very next day, my supervisor and I went over to the house to, talk more in detail about the concerns that came up. And about halfway into this meeting, LaDawn also came. She was coming that day for a visit. So she was a part of, the conversation. Mr. Boone did say right when we got there that he had guardianship over the other child, and he had for quite some time, and he's been making a lot of progress. So if by having this child in the home was going to jeopardize that, he stated that essentially if he had to pick one of the boys, he was going to care for the older one. So as we continued to talk and we asked LaDawn if she had concerns for the 2 siblings being under the same roof, she said, absolutely, I do. And when we asked her to elaborate, she said no. This was also the first time I had met with LaDawn, so I feel like there wasn't that rapport, so I wasn't really going to push at that time. We developed a safety plan, a potential safety plan, which is also attached to the second court report that I submitted. And it was suggested that the boys not share a bedroom, that maybe because they had conjoining bedrooms upstairs, that maybe a door alarm be put on because you have to pass through one door to get to the other. That the boys cannot they needed privacy for dressing, changing, bathing, and that Mr. Boone would have to supervise Sam, at all times. He had stated that he needed time to discuss the plan with the older boys in the home, because it would affect their day to day, and that he would essentially get back with us. So the next day, I believe, or I think it was the weekend. So I think Monday is when I had received a text, which is also attached to my court report, of his explanation, that maybe this home wasn't the best placement for him. Essentially, that he wasn't going to abide by the safety plan. So that day we had contacted his previous placement, which is now his placement, Tremaine, as well as the grandmother. And then we asked LaDawn, and we had an FTM if there was any other relatives that we could look for placement. Tremaine at the time didn't contact us back. She said she had talked to her husband. And when we ended up moving the child that day, it was essentially an emergency placement change because the current caregiver was not willing to abide by the safety plan. And given the length of time we had the case and this new information of possible sexual abuse taking place between the brothers for the child's safety, we wanted to make sure he wasn't going to be in that home. So at that time, he was placed in a unrelated licensed foster home.
Here's what happened. Day one after the caseworker gets this case. CPS is called. The child convinced another boy to touch a girl inappropriately. Then he discloses his older brother exposed himself multiple times in their bedroom. The caseworker creates a safety plan. Separate rooms, door alarms, supervision. The caregiver refuses and says if he has to pick, he's keeping the older brother. So the kid gets emergency moved to his aunt.
And then about 3 days later is when Tremaine had contacted me and found out that we had moved him. She said, absolutely not. I want him, I will take him back, please, and then we ended up moving the child back to the aunt's house where he currently resides.
And I believe at the last hearing, there was a question about permanency and whether that's an option for this child with his aunt. To the best of your knowledge, would she be willing to provide permanency?
Yes. I think that there was, between communication with DHS and what she had told them, I don't know where, I feel like maybe we were told different things, or maybe, I don't know if her mind, changed, or if she realized the point of the case that we were now at. Because when I had talked to her and I explained, that we always hope that regardless of where the child goes, that permanency is an option, and we want to know that right off, the bat. So I had asked her, and she said, yes, I would care for him for as long as I needed to, and I said, even if that would mean, permanently. And she said yes.
And I think I asked about this at the last hearing. There was a safety plan attached to your last report with regarding current placement in the child in the same room.
Correct.
Because there's construction happening at the homes.
Yes, the basement is currently being refinished. The last time I was there, I believe that they did have the carpet put down. So the Tremaine's son is going to be relocating and moving downstairs, and then this child would have his own bedroom. He would be moving to the other one.
Okay. So I think maybe just to understand, is there a reason that Aunt is not in the same bedroom as her husband, or that she needed to be in the same bedroom as a child?
They are not married.
Okay.
They have been together for quite some time. I think 11 years, I believe. They have separate bedrooms. She says that he sleeps downstairs. He has his own room, and then she said that either she sleeps hot, he sleeps cold. I'm not sure.
Okay.
I don't understand the dynamics.
Sure, but it wasn't.
We just established a safety plan because of the gender, role, the difference.
Okay. So it wasn't that she had to have 24/7 eyes on this child or anything. That's just how the home was set up.
Correct.
Okay. And to be clear, the request is to change the goal for adoption, correct?
Yes.
And if that request is granted, you have provided, I guess, in addition or in support of the department's previous petition, like you have looked at that and would ask the court to accept that if the court changes the goal determination positions. Is there anything else that you would like the court to know today?
I don't think so.
All right. With that, Your Honor, I have no further questions of Ms. Smith and would move to admit the report from last week and, our last hearing and then the court report for today.
I have no objection.
No objection.
Thank you. All of the exhibits from last week and this week are received. Any questions for this witness, Ms. Stang?
No, thank you.
Ms. Heiss?
Your Honor, I have no questions. Thank you.
Okay, thank you, Ms. Smith, for clarifying all of that and for taking the time to put together that additional report. You're welcome. Anyone else you'd like us to hear from, Ms. Thomas?
Your Honor, I'll ask Ms. Heiss, I asked Ms. Palm to be here as a former foster care worker because I think at the last hearing we were also a little concerned about permanence and whether and the aunt was willing to provide that. And we were getting mixed messages from before the case was transferred. And so I would ask the court or Ms. Heiss if they would like to hear from Ms. Pelham on that point and how things stood when she handed off the case to Ms. Smith.
In my capacity, I think that's something we work out between reviews. I don't think it's worth using court time unless there is a difference of opinion or, but we're probably all pulling in the same direction. So I don't need the testimony personally.
I too trust you to work it out in between.
Then I have no further witnesses. Thank you, Your Honor.
Ms. Heiss, anyone you'd like us to hear from today?
No witnesses today, Your Honor.
Well, comments in closing, Ms. Thomas.
Thank you, Your Honor. At the last hearing, well, 2 hearings ago, when we had a review privacy planning hearing, we had requested a goal change at that point in time. But Mom was also starting to maybe see the child a little more and seems motivated to engage in her case service plan. And unfortunately, in this last review period, she's sort of fallen off the radar again. We understand that she is living in a different city, and it seems that a lot of efforts have been made to try to locate providers for her and communicate with her. But she also has an equal responsibility to communicate with the agency and to comply with her case service plan. Because of that lack of compliance, this child's pretty heightened needs. We are asking the court to reconsider the permanency goal again and change that to adoption. We're hopeful that this placement can be permanent and we can get those services in place for the child. I know that we've discussed getting some therapeutic services in there. I think there might have been some issue with insurance or payment and getting that switched over. But I think that we definitely have a competent caseworker who is very capable of getting all of those things in place for that child. Otherwise, you're asking for another review, at which point in time we're anticipating that would probably be a termination hearing as well. Thank you.
Comments, Ms. Stang?
No, thank you.
Ms. Heiss?
Thank you, Your Honor. The case worker did come to the table with her legal advocate, so I'm not needed here to pick at her investigation, but I do need to point out just a few things about her investigation to emphasize as my duty to watch for the best interest of the child. I think that what we have here is that saying about, is this a legal case with a social work component? Or is this a social work case with a legal component? And we can go round and round all day because this is what I would have added to the discussion had I been included. Number one.
The Guardian ad litem drops legal truth bombs. Was forensic interviewing used? Was a child advocacy center called? Has this child seen a therapist after disclosing abuse? No, and no. A month later. He still has 0 trauma services. Law enforcement investigating. But this kid needs help now.
Unless I was included. I can't ask if forensic interviewing techniques were used at the interview. In today's investigation report, I don't see it. So in protecting this child, I need to consider that he may be the victim of a very serious crime, and you have to preserve evidence in a certain way. So to think that we didn't need the legal layer, I think is inaccurate. So then number two, if there was a CSC or a crime, a rape crime against this child, then I would have asked, can we use the CAC, the Child Advocacy Center, to do a forensic interview so that it's recorded, so that this child is under 10, we could use the tender years exception and he wouldn't have to testify. We don't get caught up on the child telling different stories to the social worker, to the police officer, to all those people, just an angle, a legal angle. So if there is a CSC here, I would say, let's have the Child Advocacy Center look at him, do the interviewing. I would say it's local, it's accessible to us. It's always been very helpful crutch. And maybe the answer would have been, oh, they're unavailable. So I would have had an answer, but I would have said, why don't the police interview if this child is a victim of a crime? Obviously, we believe the perpetrator is a minor, but still. And if we believe that it happened, I would have said, why are we this far down the line, over a month? He hasn't seen a counselor. He hasn't seen anybody. Not appropriate. He needs emergency victim services. I really believe strongly that to back him up and to say, this isn't your fault, this wasn't normal and healthy, you are normal and healthy, and to advocate some of those things, I really would. But we get this thing between Lenawee CMH, and then you move him to Monroe, and he moved school districts, he moved CMHs, and that whole thing. And I know how this goes because he was in Monroe before, and to try and get him connected to a counselor is really difficult. I still think even in the updated report that we're referring to prior sexual conduct. What? Who? Where? When? Where do we get that information? I would like to know that in helping the child. One more point is this recitation of the interview with the child, is that what we're calling sexual assault? Because I'd like to just ask. Boys share a room. The older boy pulled his pants down. Like, in my legal world, what are the elements of a sexual assault? It's not the only lens to look at an instance and say it's wrong against a child. It can be wrong before it elevates to a crime. But, I just would have liked that a little bit clearer. He pulled his pants down. Well, it's his bedroom. I've been in the bedroom. I know how the beds are arranged. I know how, anyway. So I don't know that there was sexual abuse. I'd like to have asked those questions. And then there's this blanket statement. There's prior sexual contact. I don't know where that comes from. Okay. And then I had not heard there was prior sexual contact. Other thing that I would have said, last thing is, when we say that this new placement is, she's not married, it's very significant difference in the court report and in reality. She's not married. So if she's going to be assessed for adoption, I don't believe she has any title on the house. She has no lease in the house. These are things we work on through adoption, and she would have to be evicted. She's lived there a long time. But the legal lens to say, is this placement available for permanence? She has no income. She has no housing. She has housing, but she has she could get kicked out overnight, not quite 6 months-ish, So some of those things I like to look at and just support the agency in bringing those pieces so that when we get to MCI looking at adoption, we're not surprised. And now we're a year down the line and the kid has to be moved again. And usually this placement has in the past asked for the child to be moved. A lot of times that alone knocks them out from having placement again. And I was there when we moved him. And it's not something that a family will say right out loud directly to your face. You really have to read some body language about, is she really up for placement? And maybe she's changed. But the last thing is just going forward, the caseworkers and I do these visits out in the community. Usually I wait till the kids are home from school sometimes, and then the caregiver has to be home, or the kid has to be home from daycare. And this one's in Monroe, so, his last placement was a really upstanding person in the community. I was so proud that we had a kid in this placement. I thought it was a chance for this kid to really have an opportunity in life. And I do believe the social worker took the correct steps, and we are at the correct place in this case. But I had certain commitments out in the field, and I had certain, when I called him to see the child and he let me know that he hadn't been there for a month. Now, part of that is my fault because I had a DHS 69. The caseworker did what she was supposed to do after all the changes were made. She did let me know in the file, and I missed it. She let me know that the child had been moved, but I would like you to know that I really take seriously my input that I could have had, that legal layer, getting the child right. The last thing, sorry, Judge, back up, the offending child, had we left the child there, let's have an assessment. We have some good community resources that are available to our court to get an assessment and maybe work on this and maybe support the family, or maybe that child has to leave for some redirection. I don't know. That's a little, but it either happened or it didn't, and if it didn't happen or it's not prosecutable, this was a big change. But the child's needs are being met. I've been to his place. I have met with him. I've met with his caregiver, and she has a teenage son in the home, and I met with a significant other. But anyway, so this case is on track. It's going well. I predict that I do recommend that the goal change to adoption, and I know it's in good hands moving forward, and that concludes my comments. Thank you.
Yeah. Ms. Thomas, would you like another opportunity to address a couple things that Ms. Heiss brought up?
I would just like to add that based on conversations with the agency, law enforcement is involved, so there is an ongoing investigation. I believe through that avenue, some of the things that Ms. Heiss rightfully brought up, like the SDAC interview, and making sure that forensic interviewing protocols followed, and all of that would take place through that process. I personally was a little confused as I'm used to getting MIC investigations, maltreatment care investigations, when children are in foster care and we get complaints called in. And this process really educated me into the fact that the calls were not made on the caregiver, and so it was then sent to the foster care worker to sort of do that investigation process. So some of the things that we might typically see through like the standard forensic interviewing, we didn't get that here, because I think the first one was referred to the foster care agency, and then the second one, because of the allegations, was sent to law enforcement. So I just want to be clear on that, on some of those points. I think a lot of the questions could also be answered in a family team meeting as far as the details. I think that we get stuck in this position of how much do we disclose and how much information do we give and put onto the record, and how much do we want to protect and make sure that we can give enough information but still protect the integrity of maybe individuals who are not necessarily involved, like the other minor child in this case. But I'm happy to continue to have meetings with LJL and sort of make sure everyone is brought up to speed. I think Ms. Heiss also brings up a lot of good points about the permanence of this placement, but that does not change our request at this time for the goal change.
Thank you. Well, the court finds all interested parties were given notice for purposes of today's review hearing and permanency planning hearing. There's a lot of moving parts in this one, and Ms. Smith made sure to include that screenshot to let us know that the mom in this case was fully aware that today's hearing was happening. She's been to a few hearings in the past, and despite a previous request to change the goal in this case, the court did allow her some additional time because of that particular review period. She had demonstrated some sobriety and some progress. Unfortunately, that was not something that we could see her sustain. And then, of course, there were many, many things that happened in between that hearing where she had joined us and today. But the obligation of the court remains to look at the best interest of the child, to look at permanency and stability for this child, and adoption is the correct goal for him at this point. He has an unknown putative father, and his biological mother, despite her efforts, has been unable to take advantage of the case services such that she's able to care for him. Obviously, she's not here today. There remains a significant risk of harm associated with returning him to her care for all the reasons expressed in the petition originally, including the transiency, the substances, the struggle with substance use, and how all of that impacts her child. So the goal moving forward will be adoption for this minor child. I would like to have updates on the criminal investigation and the CSC or the CAC interview as that goes along. I would like to see some triage services for the child. As Ms. Heiss pointed out, we do have a couple of providers in our community that are educated around some of these issues, at least one through Parkside. And then we have a provider that we typically see through campus, Mr. Jeff Davis, that may be inclined to do at least something preliminarily for the child that's the subject of jurisdiction of this court. In this case, I don't have jurisdiction over the other kid, or I'd send him too, frankly. And that may be the case in the future. But for today, obviously the child, which is the subject of this case, is our priority. And I think I agree wholeheartedly with Ms. Heiss's assessment of his current needs under the circumstances. So we'll look for Ms. Smith to do that referral. I would also suggest you reach out directly to the CAC, who also have some of those services in place. And if they're already going to be doing an interview with this child, they may be able to help offer some of those services. So we'll look for updates on those points specifically when we come back. Don't forget to invite Ms. Heiss to those meetings in the future. I don't think she'll probably ever forget at this point, Ms. Smith. But I think it's moved. The case, I agree that the case is moving forward. We do have a diligent foster care case manager associated with it. So some difficult things have happened, but I think the case is on track. I agree. I'll set a review, permanency planning hearing, and leave enough space in there in case the department is able to timely file and serve the petition for termination of parental rights. We are today at our fourth review hearing with a removal date of January 4th, 2024. Ms. Harden has had more than 6 months in order to try to make progress on her case services. Unfortunately, she's been able to do that. By the time we come back, we'll be nearly at 15 months. We're going to go into the last week of February for that purpose. We're going to set this for the afternoon of Tuesday, the 25th. (1:30) Yes. Unless you think you need less time, I can give you 2:30 if you think it's only going to take 2 hours.
Nope. 1:30 is fine. It just didn't hear well.
That's okay. Ms. Sims, do you think you need the whole afternoon?
No, I think an hour and a half, an hour for presentation and half hour for findings or so.
Okay, so let's go ahead and set this then for 2:30 p.m. So it'll be 2:30 on Tuesday, February 25th, 2025 for permanency and review and termination. That will also be contained in the court's order, the goal change as well as the directive to file that petition. So hopefully that's timely filed and served, and we'll be able to look at those issues on the 25th. Child, in the meantime, we'll stay with that relative placement that is the safest and least restrictive under the circumstances. Trust Ms. Smith with the triage. And unless there's any questions, I think that's all for today.
Thank you so much.
Yeah.
The order will contain the rest of the file.
Final verdict. Goal change to adoption. Mom's been MIA. No visits. Failing drug tests. The child stays with his aunt permanently. The judge orders immediate trauma services and a forensic interview. Termination hearing set for February. Mom had 15 months. She didn't show up. This kid finally gets stability.